Writs are formal legal orders issued by a court to enforce the fundamental rights of individuals. Under Article 32 of the Indian Constitution, the Supreme Court has the authority to issue writs, and under Article 226, the High Courts have similar powers. There are 5 types of writs in India: Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. Each writ serves a specific purpose in protecting the rights of individuals and ensuring justice. Habeas corpus. The term habeas corpus is a Latin phrase that means you may have the body. This writ is issued to produce a person who has been detained or imprisoned before the court. It ensures that the person is not being held unlawfully or without legal justification. If someone is unlawfully detained, their relatives or friends can file a writ of habeas corpus in the court, which then orders the authorities to bring the detainee before the court. The court examines the legality of the detention and can order the release of the person if the detention is found to be illegal. Mandamus. The term mandamus is a Latin word that means we command. This writ is issued by the court to a public official, public body, corporation, or inferior court, commanding them to perform a public duty that they have failed or refused to perform. It is typically used when a public official or body fails to fulfill their duties. For example, if a public authority refuses to issue a license to someone who has a legal right to it, the court can issue a writ of mandamus ordering the authority to issue the license. Prohibition. The term prohibition refers to the act of forbidding or stopping something. This writ is issued by a higher court to a lower court or tribunal to prevent it from exceeding its jurisdiction or from continuing to act in a matter that is beyond its powers. If a lower court or tribunal is handling a case that it has no authority to hear, a higher court can issue a writ of prohibition, ordering the lower court to stop proceedings in that case. It essentially prohibits the lower court from continuing the action. Certiorari. The term certiorari is derived from the Latin word meaning to be more fully informed. This writ is issued by a higher court to a lower court or tribunal, either to transfer a case pending before it to itself or to quash an order passed by the lower court if the lower court has exceeded its jurisdiction or violated principles of natural justice. If a lower court has made an incorrect decision or acted beyond its jurisdiction, the higher court can issue a writ of certiorari to quash the decision. This writ ensures that justice is served by correcting errors made by lower courts. Quo Warranto. The term Quo Warranto means by what authority or by what warrant. This writ is issued to challenge the legality of a person's claim to a public office. It is used to prevent an illegal usurpation of a public office by questioning the authority by which a person occupies that office. If a person is holding a public office without legal authority, a writ of quo warranto can be filed to inquire into the legality of their claim to the office. If the court finds that the person has no legal right to hold the office, it can direct them to vacate the position. These writs are powerful tools in the hands of the judiciary to protect citizens' rights and ensure that public authorities act within the bounds of the law.